The shift did not arrive with spectacle or ceremony. There were no cameras in a courtroom, no oral arguments broadcast to the public, no dramatic reading of a decision. Instead, it arrived the way the most consequential institutional moments often do, quietly, decisively, and without commentary. The nation learned the highest court in the country had declined to intervene, allowing the criminal process involving a former president to resume immediately. What made this moment extraordinary was not the legal mechanism itself, but what it dismantled. For years, the former president's legal posture relied on a single structural assumption that time could be stretched indefinitely. Appeals, motions, procedural disputes, and jurisdictional arguments were not merely defensive tools. They were the strategy. The goal was never to win decisively in court, but to ensure that the court never reached the stage where decisive outcomes could occur. That strategy had worked until it didn't. By refusing to pause the proceedings, the Supreme Court did not issue a ruling on guilt, innocence, or punishment. It did something far more institutional. It declined to suspend the normal operation of criminal law for a former officeholder. In practical terms, that decision removed the last procedural barrier that had kept multiple cases frozen in place. Legal observers immediately understood the implication. Once the appeal was denied, the rulings of lower courts became active again. There was no buffer period, no administrative delay, no opportunity for recalibration. The legal system, which had been waiting, resumed its forward motion. The significance of this cannot be overstated. Appeals function as brakes. They slow proceedings, preserve the status quo, and prevent irreversible steps while legal questions are reviewed. Once those brakes are removed, the system accelerates quickly. Investigations restart. Prosecutors regain authority. Judges reclaim full control over their calendars. What surprised many analysts was the court's restraint. There was no explanation, no written opinion, no effort to frame the decision politically or philosophically. The message was conveyed through silence. The court treated the matter as procedurally unremarkable, even as its consequences were historic. This restraint sent a signal. The court was not interested in redefining presidential power. It was not interested in inventing new doctrines of immunity. And it was not interested in insulating former leaders from accountability. By stepping aside, it allowed existing legal principles to operate as they always have. Those principles are straightforward. Executive authority ends when a term ends. Former presidents retain no special criminal protections. Actions taken while in office are not categorically immune from prosecution. These ideas are not radical, they are foundational. What made this moment unusual was the identity of the defendant, not the law itself. Inside political and legal circles, the reaction was immediate. Strategies built around indefinite delay collapsed overnight. Advisors who had promised more time could no longer offer it. Legal teams faced a compressed timeline with no procedural escape routes remaining. The psychological impact was equally significant. For individuals accustomed to navigating crises through negotiation and leverage, the realization that no higher authority would intervene was destabilizing. The assumption that institutional alignment might provide protection proved false. The court chose institutional continuity over personal loyalty. This moment also reshaped public perception. For years, many citizens believed that power insulated elites from consequences. The resumption of proceedings challenged that belief. It demonstrated that delay, while effective for a time, is not permanent immunity. Politically, the timing could not be more consequential. The legal process is now moving forward during an active election cycle. That collision was not engineered by the courts. It was the inevitable result of delay finally reaching its limit. Importantly, this development did not resolve the underlying cases. It did not determine outcomes. What it did was restore motion to a system designed to move deliberately but persistently toward resolution. The era of suspension ended in silence, and with it ended the illusion that accountability could be postponed forever. Once the appellate barrier fell, the transformation inside the federal court system was swift and unmistakable. What had existed in a holding pattern, motions drafted but not argued, hearings anticipated but unscheduled, suddenly moved into active status. Judges resumed authority over their dockets. Prosecutors reactivated litigation plans that had been on pause. The legal process transitioned from abstract debate to concrete preparation. This stage matters more than any before it because it marks the shift from legal theory to factual examination. Appeals revolve around ideas, jurisdiction, immunity, constitutional interpretation. Trials revolve around evidence. That transition fundamentally changes the balance of power. Trial judges are no longer constrained by uncertainty. During appeals, courts often avoid scheduling or issuing substantive rulings to prevent conflicts with higher courts. That caution has ended. Judges can now set firm timelines, rule on pending motions, and enforce compliance with court orders. One of the first areas affected is jury preparation. In a case of this magnitude, jury selection is a complex and deliberate process. Potential jurors must be identified, screened, and questioned to ensure fairness. Security arrangements must be coordinated. Procedures must be established to manage media attention and public interest. All of this had been delayed. It is now moving forward. Witness testimony represents another critical shift. During the appeal phase, many potential witnesses remained in legal limbo. Some declined to testify while immunity arguments were unresolved. Others asserted privilege claims linked to executive authority. With those arguments rejected, the scope of permissible testimony expands significantly. Former aides, advisors, and officials who were once shielded by unresolved legal questions now face enforceable subpoenas. Their decisions carry real consequences. Refusal can result in contempt. Cooperation can mitigate personal exposure. Historically, this phase often produces increased witness participation. The evidentiary phase also comes into focus. Thousands of documents, communications, and records that were previously sidelined now become central. Courts will rule on admissibility, relevance, and scope. Prosecutors will begin constructing narrative timelines supported by documentation and corroborated testimony. This is where criminal cases gain clarity. Assertions are tested, inconsistencies are exposed. The strength of a case becomes visible, not through press statements, but through exhibits and sworn answers. The defense now operates within narrower constraints. Without immunity arguments, remaining strategies focus on intent, interpretation, and credibility. These defenses are legitimate, but they are harder to sustain when evidence aligns across multiple sources. Judges overseeing these proceedings are keenly aware of the stakes. They must ensure fairness while maintaining momentum. Excessive delay risks undermining public confidence. Excessive haste risks claims of prejudice. The balance is delicate, but the framework is familiar. Security considerations intensify as proceedings resume. High-profile trials attract threats, protests, and heightened emotion. Federal marshals and court officials prepare accordingly. These measures are not symbolic. They reflect real risk assessments. The political context adds another layer of complexity. Statements made outside the courtroom can have legal consequences inside it. Attacks on judges or prosecutors can trigger sanctions. Attempts to influence witnesses can result in additional charges. The boundary between politics and law becomes increasingly consequential. Media coverage will shift as well. Trial-level litigation produces tangible content, transcripts, filings, testimony. Over time, evidence tends to crowd out speculation. The narrative becomes harder to control. For the justice system, this phase is about demonstrating competence and neutrality. The goal is not to make history, but to apply the law as written. The system's strength lies in its routine functioning under extraordinary pressure. This is the point where myths often dissolve. Criminal trials are methodical, procedural, and constrained. They reward consistency and punish contradiction. They are not platforms for persuasion, but forums for proof. With the appellate phase complete, the system is no longer debating whether it can proceed. It is proceeding. And once that process begins in earnest, it rarely stops. As the legal process moves decisively into its trial phase, the political consequences are no longer theoretical. What once unfolded behind closed courtroom doors now exerts direct pressure on party structures, campaign strategies, donor networks, and institutional stability. The collision between criminal accountability and electoral politics has become unavoidable. For months, ambiguity functioned as a political buffer. Lawmakers, candidates, and party officials avoided definitive positions by pointing to unresolved appeals. The language was consistent and deliberately vague, allow the legal process to play out. That posture is no longer sustainable. The appeals have concluded. The process is playing out, visibly and rapidly. This forces recalculation across the political spectrum. Alignment now carries measurable risk. Distance carries its own costs. Silence is increasingly interpreted as evasion. In private, strategists acknowledge that the landscape has shifted irreversibly. Campaigns built around certainty are now planning for volatility. One of the earliest fault lines appears in fundraising. Political donations are driven not only by ideology, but by perceived viability. Criminal proceedings undermine predictability. Legal defense costs escalate quickly, drawing resources away from traditional campaign infrastructure. High-value donors, particularly institutional contributors, tend to withdraw when risk outweighs return. This shift is already evident. Messaging aimed at donors is becoming more defensive, less aspirational. Appeals emphasize endurance rather than inevitability. Historically, this transition signals contraction rather than growth. Movements built on momentum struggle when momentum stalls. Party leadership faces structural dilemmas that modern American politics has never confronted. Nomination processes assume candidates free to campaign without legal encumbrance. A defendant required to appear regularly in federal court introduces uncertainty at every level: scheduling, messaging, debate participation, and convention planning. Contingency discussions are occurring quietly but urgently. While public unity is maintained, internal conversations reflect concern about downstream effects, down-ballot races, coalition stability, and voter turnout. Political organizations are risk-averse by design. Prolonged legal exposure amplifies that instinct. Public reaction is also evolving. Initial shock has given way to normalization. The extraordinary is becoming procedural. Hearings are scheduled, motions are filed, witnesses are listed. Over time, this regularity reshapes perception. What once felt unprecedented begins to feel institutional. This normalization has consequences. It reduces the effectiveness of claims that the process itself is illegitimate. Routine court activity undermines narratives of exceptional persecution. The more the system functions predictably, the harder it becomes to portray it as arbitrary. Media dynamics contribute to this shift. Trial-level proceedings generate tangible material, transcripts, exhibits, sworn testimony. These elements anchor coverage in verifiable facts. Speculation loses ground as documentation accumulates. While sensationalism persists, evidence exerts gravitational pull. International observers are taking note. Democracies accustomed to prosecuting former leaders view the proceedings as confirmation of institutional resilience. Others see cautionary lessons about polarization and governance under stress. The United States is being evaluated not on outcome, but on process. Foreign ministries are pragmatic. Their primary concern is continuity, whether governance remains stable, elections proceed normally, and legal outcomes are respected. Thus far, the system is holding. Courts are functioning. Agencies are coordinating. Transitions continue uninterrupted. The defendant's public response will continue to influence this phase. Rhetorical escalation can galvanize supporters, but it also carries legal risk. Courts are not passive actors. Threats, intimidation, or attempts to influence proceedings invite enforcement. The judiciary possesses tools to protect its process. This dynamic creates tension between political instinct and legal necessity. Campaign rhetoric rewards confrontation. Courtroom discipline penalizes it. Navigating both simultaneously is inherently unstable. For voters, the moment reframes civic judgment. The electorate is not tasked with deciding legal guilt. That responsibility lies with jurors. Voters are asked to assess leadership amid accountability. The presence of criminal proceedings becomes part of the political context, whether welcomed or not. This is not unprecedented globally, but it is unprecedented domestically. American democracy is encountering a stress test it was designed to endure but rarely forced to confront. Institutions are responding not with improvisation, but with adherence to procedure. That adherence is their strength. The system does not adapt to personalities. It applies rules. As the trial phase approaches, political uncertainty will intensify. But beneath the turbulence lies a steady process moving forward, unconcerned with polling cycles, messaging strategies, or partisan advantage. That reality defines the moment. As proceedings advance, the long-term significance of this moment comes into focus. Beyond verdicts or sentences, the enduring impact lies in precedent. What this episode establishes about power, accountability, and institutional resilience. The Supreme Court's decision not to intervene did not introduce new doctrine. It preserved existing law by refusing to weaken it. This restraint carries profound implications. Future presidents now govern with clearer understanding. Authority ends with office. Legal accountability does not. Precedent is often misunderstood as dramatic rulings or sweeping opinions. In reality, it is built through consistency. By declining to create an exception, the court reinforced continuity. The legal system treated a former president as it would any other defendant, no more, no less. This consistency matters because democratic systems rely on predictability. Laws lose legitimacy when applied selectively. By allowing the process to proceed, institutions protected themselves from erosion. The judiciary now bears significant responsibility. Judges overseeing the case must balance firmness with neutrality, speed with fairness. Their role is not symbolic, it is operational. Every ruling contributes to public confidence or skepticism. This scrutiny is unavoidable, but courts are equipped for it. Procedure exists precisely to manage pressure. Rules constrain discretion. Transparency limits abuse. These safeguards are not ornamental, they are functional. The defendant's experience illustrates a broader lesson about power. Influence can shape narratives, delay outcomes, and mobilize support. It cannot override evidence or suspend process indefinitely. Courts are designed to absorb pressure, not yield to it. Public trust, long strained, stands to be reshaped by this episode. Many citizens doubted whether accountability applied equally. The continuation of proceedings challenges that assumption. It suggests that while delay is possible, exemption is not guaranteed. This does not mean outcomes are predetermined. Trials exist to determine facts, not confirm expectations. But the opportunity for determination itself carries meaning. Internationally, the signal is complex, but instructive. The United States demonstrates that legal accountability can coexist with political turbulence. At the same time, the spectacle exposes vulnerabilities: polarization, distrust, and rhetorical extremism. Other democracies will study both aspects. Strength and fragility are not mutually exclusive. They often coexist. As the trial unfolds, attention will shift from personalities to process. Witness testimony, cross-examination, and documentary evidence will define the narrative. Emotion yields to record. Assertion yields to proof. This phase is clarifying. Criminal trials are not persuasive performances. They are structured examinations. They narrow ambiguity. They impose discipline. The psychological dimension is significant. For individuals accustomed to control, the rigidity of court procedure can be destabilizing. There are no alternative venues, no parallel processes. The courtroom is final. This is where accountability becomes tangible, not as rhetoric, but as experience. The political system will continue to adapt. Some actors will distance themselves. Others will entrench. Parties may fracture. Coalitions may shift. These are consequences, not causes. The legal process did not create political polarization. It intersects with it. The electorate, too, will evolve. Voters respond to stability, clarity, and legitimacy. How institutions conduct themselves now will influence public confidence long after this case concludes. History will judge this period not by slogans or headlines, but by institutional behavior. Did courts apply law consistently? Did political actors respect process? Did the system endure stress without breaking? So far, the answer leans toward resilience. The final appeals are exhausted. The process is active. Accountability is no longer abstract. Whatever outcomes emerge will do so through established mechanisms, not exception. That distinction defines the rule of law. This moment will echo beyond any single verdict. It will shape expectations of leadership, responsibility, and consequence. It will inform how future power is exercised and restrained. The system has resumed its course. It did not pause for influence. It did not yield to pressure. It moved forward. And in doing so, it reaffirmed a principle as old as the Constitution itself. Authority may be temporary, but the law endures.